and welcome to Cuyahoga County's Community Development Committee meeting. It's Monday, June 5th. Madam Clerk, can you call the roll, please?
Good morning, everyone. As a reminder to all in attendance, this meeting is being recorded and live streamed on the county's YouTube page. It is now 10:08 a.m. Calling the roll. Ms. Stevens?
Present.
Mr. Jones?
Here.
Ms. Simon? Ms. Simon is absent at the moment. Mr. Gallagher? Mr. Kelly? Mr. Kelly is absent at the moment. And also for the record, Councilmember Dale Miller is in attendance. You have a quorum.
Thank you. Is there public comment this morning?
Yes, there is. First public comment is Marjorie Glick. Ms. Glick, is your microphone on? Is the green button pressed?
There we go.
Thank you.
Try that again. Margie Glick, and I'm the Advocacy Director at Lutheran Metropolitan Ministry, and I'm here to express LMM's support for the county's pay-to-stay legislation. LMM manages the men's shelter at 2100 Lakeside, which is the largest men's emergency shelter in the state of Ohio, and we also manage the family overflow shelter, Haven Home. We know firsthand the pain that evictions cause for individuals and families. It is common for families to end up in our shelters following an eviction, and an eviction is most often due to non-payment of rent. Once someone has an eviction on their record, it can be a major hurdle to finding a new place to live. It's a cycle that can keep someone in shelter or sleeping on the couches of their friends and family. Pay to stay provides an important affirmative defense for someone who may need just a few more days to cobble together their rent and any applicable late fees. At a time of rising cost and of everyday cost and rent due to inflation, it's important that Cuyahoga County do more to ensure residents are given the opportunity to stay in their homes and can avoid the emotional and financial consequences that go along with an eviction.
Good morning. I went through the eviction.
Excuse me, sir, if you could state your name for the record.
I'm sorry, Ronald Ware. And excuse me. I went through the eviction situation also, and it was because of just like one day that I didn't have no, I wasn't able to pay the rent. I was pretty much evicted. I wasn't knowing that the fact that I had to go through the process of the court situation to be evicted, but he evicted me, and he didn't even have the house anymore because of the taxes. He didn't pay the taxes, but he didn't tell any of us that. It was a two-family house. So that had me to go down on 2100 because I didn't have anywhere to go because he kicked me out. So I was on it for like 4 months, and they got me housing and stuff like down there. But that was the situation down there. But he evicted me. And like I say, I didn't know about the process that it supposed to go through. But I was evicted. And people shouldn't be getting evicted for just because they couldn't pay nothing for like, at least 10 days, at least. Give them a chance, because my job that I was working, I was doing plumbing work, so my money wasn't coming through as much. And okay.
Thank you.
Madam Chair, for the record, we have a letter of support that I have submitted, and it's at the dais for you. In writing, it's from the Fair Housing Center for Rights and Research, and it was submitted by Chris Kenneray in support of this legislation.
Thank you.
Okay.
Is there anyone else?
As far as the regular public comment, that concludes the regular public comment, and then we can go into the list that you have.
Okay. But before we do that, I realize that we need to approve the minutes from the May 30th meeting.
Yes.
Have my colleagues had a chance to look at those minutes?
Yes, I'll make a motion that we approve the minutes as presented.
Is there a second? I'll second. All in favor?
Aye.
Any opposed? Hearing no opposition, the minutes for the May 30th meeting have been approved. Would you read the item that has been referred to this committee into the record, please?
Ordinance 2023-0004, an ordinance enacting the right of county renters to pay to stay and declaring the necessity that this ordinance become immediately effective.
Thank you. Mr. King, are you prepared to give us an overview of this, please? Thank you.
Yes, thank you, Madam Chair. Again, this ordinance has been heard in committee before, but just as a reminder, it is an ordinance that would give tenants in Cuyahoga County the ability to assert an affirmative defense when eviction proceedings are brought against them, to allow them to stay in their home if they tender full payment of rent and reasonable late fees. I believe there's a proposed substitute before us today. I'm happy to get to that if and when it's appropriate. But in a nutshell, it basically allows tenants to tender rent either prior to or following an eviction proceeding, and would allow them to assert in either housing court or municipal court, whatever the appropriate venue depending on where in the county they live, the ability to assert that right, that defense, and foreclose or end eviction proceedings against them by tendering that rent. I'm happy to answer any questions about the ordinance as introduced.
Do any of my colleagues have questions of Mr. King before we speak to some of our expert witnesses? No. Thank you, Mr. King. Oh, I'm sorry.
Yeah, Mike, in the heading, it's like, it says enacting the right of county renters to pay to stay. Do we have the authority to present a right to residents of Cuyahoga County that are not afforded by law in the state of Ohio to anybody else in the county, in other counties?
So, I mean, that is a term that I think is meant to be holistic for the intent of the legislation. The actual statutory provisions that are enacted in here are about they are rights, but there are the rights to assert defenses in individual eviction proceedings. So it is not a right in the same sense that you'd, I think, consider a right like a constitutional right that would be afforded under.
Who determines reasonable fees?
Reasonable fees are defined in the ordinance. They are defined, here, let me see, as a reasonable late fee is a total amount of the late payment for any month that does not exceed the larger of $25 or 5% of the contracted monthly rent.
And what happens, like we have out in Strongsville, where the Berea Court refuses to recognize the city ordinance?
In that instance, if a municipal court were to refuse to recognize the ordinance, the question would likely be litigated at an appellate level. Whatever the appropriate appellate venue is, ultimately, it could be decided by the Ohio Supreme Court as the arbiter of Ohio law. But that would come down to a tenant asserting a right, a court refusing to recognize it, and then that being litigated and appealed from there.
And finally, the okay, that's it. Thank you,
Madam Chair?
Madam Chair. First, Mr. Jones, and then Mr. Miller.
Just to follow up on Councilman Gallagher's question around the courts, is there something more involved in just the city opting out? Traditionally, if they don't want a legislation that we put forward, they can opt out. Is there something more involved in what are the mechanics of this around the courts?
That's correct. Thank you for the question. The ordinance specifically provides basically a provision, includes a provision that alludes in a way to our charter, which is how the conflict analysis works between county and municipal ordinances. And basically, under our charter, the county has all of the same local police powers as municipalities do, but if there is a conflict between a county ordinance and a municipal ordinance, the municipal ordinance wins out or prevails. And so the way this is drafted essentially says that if a municipality has enacted legislation pertaining to a tenant's right to pay to stay, and that legislation conflicts with the county's ordinance, then the municipal ordinance shall govern. Now, that also applies prospectively. So if there were a municipality that wanted to opt out, it would require their city council to enact legislation essentially electing to do so. But yes, any municipality has the ability to opt out of this ordinance.
Question. Why do we continually use the opt-out and not opt-in?
I think it's by nature of the way the charter establishes the council's.
I think it's by way of nature of trying to force cities to do something that they may not want to do, or if it's a touchy situation, to put them in an awkward position. We've done this before. If a city wanted to do this, they would do it, and some cities have done it.
Correct.
What does the county have any business telling cities what to do? And if you don't want to do it, you have to officially opt out.
I think it's, and I defer to the sponsor on sort of the policy question I think you're asking, but I think it's mainly a change in what I would consider to be the default rule, right? Right now, the default rule is no affirmative right exists countywide, and so cities have been individually enacting to opt in to grant that right. This would essentially change the default to this right is available to everyone within the county, and then if cities have the desire to opt out, they can do so.
And as we've experienced in the past, as soon as Columbus finds out we're doing something like this, they pass a law that says no, and then it's all for naught, correct?
That has happened in the past. I can't predict the future, but that is certainly a possibility.
Oh, I think I can see the future on that. Thank you.
Madam Chair.
Go ahead, Mr. Miller.
So I'd like to say a few things about this ordinance. First, regarding the relationship with the municipalities. We do not want to force anything on municipalities that they do not want, and so to head off that possibility. For this hearing, we sent a letter to the mayor of every municipality and the council president of every municipality in Cuyahoga County, inviting them if they had any comments or concerns to come to this hearing and provide testimony, or alternatively to send it to us in writing. And I talked to a number of communities where they told me that they have a lot on their plate and they don't particularly want to go through the process of passing their own ordinance, but they would be very happy to operate under the umbrella of the county-wide legislation if we were to pass it. The other thing that I want to say is that that following discussion of legal issues during the first hearing, we consulted further with the law department, and their legal advice was that the biggest problem with the as-introduced version is that it directs municipal courts to take certain actions, which due to separation of powers we cannot do. The as-introduced version contains several provisions, such as After the following of an action under Ohio Revised Code 123 for non-payment of rent, but prior to the execution of the eviction judgment, if the tenant tenders all past due rent amounts, including reasonable late fees and court costs, the landlord shall notify the court, who shall vacate the eviction judgment and dismiss the eviction against the tenant. The proposed substitute removes these directory sections and simply states that full payment of rent and reasonable late fees shall be an affirmative defense. So, while not as strong as the original, many municipal courts have been inclined to follow pay-to-stay ordinances, and I believe this version will help tenants avoid unnecessary eviction. So, at the appropriate time, I would appreciate if one of the members of the committee would make a motion to accept the substitute and make that the version before the committee. Thank you, Madam Chair.
Mr. King, should we amend now?
If the committee is so amenable.
And then the testimony would be on the amended from our partners in leadership in the communities.
Correct, and I believe the sponsor sent, Councilman Miller sent the proposed substitute to those who plan to testify.
That is correct.
Okay.
And the proposed substitute is in your packet on page 10.
All right, if you would read the proposed ordinance amendment.
An ordinance number 2023-0004, enacting the right of county renters to pay to stay and declaring the necessity that the ordinance become immediately effective.
And so which sections are we looking to change?
I'm sorry, go ahead.
Sorry. You'll see a red line version in your packet of the changes. I think, as Councilman Miller indicated, that the ordinance does three main things and mainly aligns the ordinance to the ordinance enacted previously in the city of Cleveland. And it does three things. One is it deletes language imposing an affirmative obligation on landlords to accept the tender of rent, but keeps that affirmative defense for tenants who offer to tender rent. So it doesn't specifically require landlords to accept rent, but simply says that if the landlord doesn't accept rent, then the tenant has an affirmative defense in an eviction action. As Councilman Miller stated, it eliminates a section giving tenants the ability to tender rent once an eviction judgment has been entered by a court, but before the eviction has been executed. So the affirmative defense can only be asserted before the final judgment, not after. And then finally, there's clarifying language added to the definition of tender to specify that that tendered rent includes potential emergency rental assistance that may be available to tenants. And that is the substance of the proposed substitute.
Okay. So the best way to handle this is to allow for discussion after we put the motion in place. Is that correct?
It's at the discretion of the committee. Either the committee could adopt the proposed substitute as the one before you, and then you could engage in discussion, or you could.
But we don't vote.
You could vote to adopt the proposed substitute if you wanted to, but it would still the legislation would still remain in committee until a vote to refer it out would take place.
Okay. So now we need to adopt the amendment as what and make it what we're formally hearing, correct?
Correct, yes.
Okay. I need a motion. Oh, so moved with a second. All in favor? Aye. Hearing any objections? Hearing no objections, we now have adopted the amendment to the legislation, and we are about to hear from a series of folks who have a perspective on this. Certainly.
Mike, just take, and I'm truly confused as to process here. So somebody doesn't pay their rent, and the landlord goes to court to evict them. What happens from there? And assuming that the person wants to pay their rent, go ahead.
So if someone doesn't pay their rent and the landlord goes to court to evict them.
One time? One,
Could be one time or multiple times, but
Okay.
assuming the landlord goes to evict them specifically for the late payment of rent, because this legislation doesn't deal with evictions for other reasons, but specifically for the late payment of rent, this ordinance would give the tenant an affirmative defense at any point up until a final judgment by the court saying that the tenant should be evicted. The tenant has the right to tender all late payment that may be due to date, plus reasonable late fees, to the landlord and assert that as an affirmative defense against the eviction action.
What if they don't? What if they file this, and as we all know, evictions last quite a while. So now we have a person that, say they just walk away. Now you have a landlord with a loss. Are we subject to paying for that loss?
Not under this ordinance.
Who's subject to making that person whole?
Well, the
As of and for, but for this, they probably would have had another renter in there. Who makes that person whole?
at the end of the day, the tenant could be ruled liable for that amount. I mean, at the end of the day, I think it's uncommon for tenants who are that late on rent to actually make the landlord whole. But the eviction, in that instance, the eviction action could and would likely proceed to an eviction, at which point the landlord could execute an eviction and
My
find a new
concern
tenant.
is that eventually somebody's going to sue us and say, had it not been for you, I'm out X amount of dollars, pay up. And as we all know, the cash cow that Cuyahoga County is, we end up paying up. Are we setting a precedent here that is going to cost the taxpayers of Cuyahoga County substantial sums of money? And are the cities that, they don't have to opt out. So we pass this, they don't have to opt in either, right? They're already in. So we're doing the overhead, we're doing all the work for free. And as we all know, nothing is free when you're talking about tax dollars. And this landlord gets baked out of, say, a year worth of rent, and the person walks away, and nobody in their right mind is going to go after that person because they don't have the money. So somebody's got a loss here. And in the law, how do you fill that void of loss? If you're the landlord, what do you do?
I think that the question about the county's potential liability here comes down to whether or not the landlord would have, well, there are a lot of questions involved,
I
including
understand,
potential
and that's why I
constitutional
have concern.
sovereign immunity.
Your premise
Right.
is basically, they want to stay and they want to pay.
Correct.
It-
But
And there's reality that goes another way, and I'm trying to figure out, have we covered that other way? And I don't think we have, because legally, no one's really challenged this, and I sense that once it does get into the courts, that we're going to be held liable, because quite honestly, we would be.
I guess I'm struggling to find a situation in which a landlord who does not avail themselves of the affirmative defense passed in this ordinance would negatively impact how this ordinance would negatively impact landlords. Currently, you're correct, evictions can take a long time, but this ordinance, assuming a tenant does not avail themselves of the affirmative defense in this ordinance, does not extend or otherwise impact the length of those existing eviction proceedings, if that makes sense.
Okay, it doesn't. And I know you're struggling to make it make sense, and it just seems to be a well-intended thought. But if we put all well-intended thought into law, where would we be? I think we'd have a mishmash of things going on here. But I'd like to hear from these experts, and I would assume there's the opposition too, so.
We actually do
thank you.
have someone from legal aid.
Madam Chair, I have one
Go
other
ahead,
question.
Mr. President.
Mike, of the 59 cities in Cuyahoga County, how many have legislation like this, and does this parallel any of them? Are there any similarities or differences between our legislation and what already exists in the community?
Yes, I believe currently there are at least 8 municipalities within Cuyahoga County that have enacted some form of pay-to-stay legislation, including the cities of Cleveland, Cleveland Heights, Lakewood, Euclid. I don't have the list in front of me, but a handful of them have enacted similar legislation. They are all, I would consider to be in nature similar. There are some differences in terms of how they're implemented. Some of them include language that was in the as introduced version of this legislation, which would have allowed tenants to assert that defense even after an eviction judgment had been entered, but before the eviction had been executed. Others mirror what the proposed substitute looks like. So there are I would consider to be technical differences between different ones. Some of them are time limited, so were introduced and have sunset provisions. Others include, provisions about the number of times the defense can be asserted between a particular landlord and tenant. So there are different variations, but by and large, this ordinance generally mirrors the form of the legislation that the municipalities have adopted, and I would say the current version most closely aligns with the City of Cleveland's ordinance.
How many times can a tenant assert this right within this?
In the current version does not place a limit on the number of times a tenant can assert this defense, but it does require them to tender all past, when they do assert it, they do need to tender all past late payments, late rent, and reasonable late fees. So if there's a backlog or multiple months of late payment, they would need to tender that full amount.
Okay, all right, thank you.
Madam Chair?
I'm sorry.
Thank you.
Let's begin testimony and hear what our community has to say to us.
Yeah, Councilwoman Andrea Mitchell.
Ms. Mitchell, if you would come to the podium, please. Once again, even though we know who you are, please identify yourself and the organization that you represent.
Oh, sorry. Did you get my name recorded? Okay. Andrea Mitchell, City of Warrensville Heights. And we have adopted a pay-to-stay legislation, and one of my colleagues, Walter Stewart, is here as well. This directly affects him, as a higher percentage of people in our city or our municipality are subject to these situations, which came to light during the pandemic, during the peak of the pandemic, where people were giving a little bit of grace, but you do have landlords who, because of Ohio's law, they have a 3-day eviction. And a lot of the tenants wouldn't know that they only have 3 days to come up with some money, or you're going to be evicted. This actually gives the landlords an opportunity to be made whole. I don't understand how the county would be on the hook, because they would probably get more revenue if someone were to do this utilizing pay to stay, because until they have the right to stay, but they have to make the landlord whole in order for this to go and get into effect. So I don't understand how the hardship would be on the landlord. This is something that is needed to safeguard people, because not having only 36 hours or a little more, 72 hours to pack up your stuff, and your stuff is outside, is unconscionable. if someone has experienced some difficult times. And that's the reason why we embrace this one, because the way Ohio State's law is, you don't have that safeguard. Now, what this does on both ends, it gives the landlord an opportunity to recoup the money that they would not have if they evict. They won't get the money, and they will get rid of the tenant. This way, a tenant has a place, a safe haven, a place to stay, and extra time to get the money up until final judgment. So I don't understand how this could be a hardship on the county or the municipality, and why anyone would want to opt in, have the opt-in provision, because as laws are made, you want to have something that is a blanket and give them an opportunity to opt out. But you would want to make sure that people are looked after in our county. And that's the only comment that I have to say. And as I said, my colleague is here. I didn't know, but he's on the list to speak. Walter Stewart really faces this on a daily basis. And this is something that really has been a help for a lot of us.
Thank you. And by the way, Mr. Stewart will be asked to speak a little bit later. Madam Clerk, I believe our next person is Mayor Traore from Newburgh Heights. Ma'am, are you? I'm sorry, I didn't see you. If you'll come to the podium. Welcome.
Good morning. Good morning, Chairwoman Stevens, and to the rest of the committee. Again, my name is Mayor Gigi Traore from the Village of Newburgh Heights, and it is my pleasure to join you to provide public comment regarding the proposed substitute ordinance 02023-004, better known as Pay to Stay. During my tenure as councilwoman for the Village of Newburgh Heights, as well as during my tenure in leadership as the council president pro tempore, I introduced and passed pay to stay legislation at the local level. One of the reasons I did that, the Village of Newburgh Heights, which as we all know is a part of the county, has three main sectors that were impacted heavily by the COVID pandemic: service, construction, and manufacturing. Those three sectors saw a very high decrease in terms of their wages, employment opportunities. And when you think about the positioning of the village, along with other communities, we had to do something. The Village of Newburgh Heights is a majority renters community, but what we want to highlight is that those renters are long-term renters. They are in the community for at least 5 years. They are a very integral component of how we operate and make sure that we stabilize our housing. And this protection was very important for not just the residents of the Village of Newburgh Heights, but also as a part of the First Suburbs Consortium. One of the primary things that we saw that came out of our housing study was that across the board, majority, I believe it was about 80%, wanted to see a countywide pay to stay piece of legislation. And so thank you to Councilman Dan Miller for taking the step and introducing this. This will greatly impact how we retain residents, how we stabilize our communities, but also how we attract businesses. They want to see stability. They want to see an emergency consumer that's able to stay. And so that could be anything from an aging elder woman who has transitioned from her home that's able to stay and rent from an apartment or a senior high-rise, or a single mother. As personally, as a long-term renter, and I don't ever see myself buying a home, but this is something that is integral to help to sustain. As we know, some communities say renters don't matter. I'm here to say the complete opposite. As someone who's been involved in local politics, from a volunteer now to as a mayor, I see that these things are very important for us to make sure that we stabilize not just our local municipalities, because there are 8 of us throughout Northeast Ohio that has implemented pay to stay legislation, but also as a county. It is so important that you all take this initiative and set a precedence for the rest and protect our residents as we continue to move forward. And so in closing, I do want to say is that one of the things that I saw in the legislation that's in the Village of Newburgh Heights that I didn't see in the county one is that we set the amount for what's called reasonable late fees. In the village, we set it at $25 to 5%, and I'm not sure if that was in this proposed legislation, but I think that is something so that it's not an overburden. As we come out of COVID, we know that a lot of the financial support is going away, but we want to ensure that we have something that's there that's reasonable for our residents so that they continue to keep their kids in the same schooling system, that they're able to depend on the reliable transportations that they have set a pattern in, and that they're able to participate and be engaged residents in the community in which they have grown. Again, my name is Mayor Gigi Traore. I support this piece of legislation as a councilwoman who introduced and passed it in the Village of Newburgh Heights, but also as a resident for Cuyahoga County. Thank you very much.
Thank you, ma'am.
Can I ask a question,
Oh,
Mayor?
Mayor, if you'd come back, please.
Well, Mayor, thank you for being here today. My question is, was that a cap of $25 on what the late fees could be, or? just a little
5%?
clarify-
5% was the cap
5%.
of the monthly rental lease agreement amount,
$25 was,
the minimum. So it actually says no greater than 25%, $25 or 5% of the monthly lease agreement amount, whichever is greater,
how long has your legislation been in place?
since 2021. Yes. And one of the things I did want to mention, myself and Mayor Annette Blackwell, we partnered together and put a information piece together that goes out from the local municipal court, which is, for us, it's Garfield. And so that goes out to all residents who are facing eviction for the non-payment of rent. And so we want to make sure that we're continuing to educate our residents about the resources that are available as well.
Have you seen the positive impact from?
I have. There was some opposition. Of course, you probably hear some today, but where property owners, whether they're international, in the Village of Newburgh Heights, we have property owners that live in other countries, that live in other states, and so there was some pushback. But what we're able to see, I just recently appointed 2 renters to my Fair Housing Review Board Committee. And what that does, it helps to balance out how we engage residents. And once you engage a resident, that keeps them long-term. And so the positive impacts is that we're not shifting families, right? We're keeping them whole. We keep them with access to to all the resources that they're accustomed to doing and the routines that they have set in their house. I think probably from some of the speakers today, you've probably heard about how you upheave a family and how that impacts not just that family individual, but how it impacts the community that they're engaged in. So the positive effect is that we continue to be able to serve and provide input with those residents.
Mayor, are you aware of any complaints from mayors in the moment in terms of someone using this particular right and hearing any type of complaint from a?
Not at this point, because at the end of the day, they will be able to tender all rent. So I saw in Councilman Miller's legislation, very similar to the other 8 municipalities that have passed it, is that you get all the rent. So that's inclusive of the late fees as well as the court costs and any back rent that's due. So they're made whole completely throughout this piece of legislation in the 8 local municipalities. And if you guys decide to pass it, same thing with the county. So I think at the end of the day, it's about, one, they don't want to have to forego any payment, but also what it does, it's a benefit to the landlord as well, or their property management companies, because once you evict someone, you then have to go back. You have to clean. You have to put it up for marketing, for promotion to say that this place is open. All those kind of things that are, extra expenses. Whereas if you just accept and you're made whole, then you're able to just continue with the same family.
Thank you.
You're welcome. Any additional
Hold on,
questions?
just
Madam
hold on a
Chair.
second. Mr. Gallagher has a question for you.
Yes.
Mayor, thanks for being here. You had this since 2021.
Yes.
How many people have gone through the process?
I do not know. That is something the local municipal court will be able to answer.
So the Garfield Municipal Court allows this in their jurisdiction,
That's correct.
okay? Because in mine, Berea said no. And my concern here is the mechanics of all this also. Is the city can say something, but is that a law in Ohio that the Berea or Garfield or Cleveland Municipal Court can follow? And if it isn't a law established by the legislature, then there's no appeal. And if there's no appeal, you have a dysfunction in the law here.
I understand what you're saying, but and I don't want to speak out of turn because, one, I'm not an attorney and I don't work for the Garfield Municipal Court. But what they're saying is that because it is a passed and acknowledged codified ordinance within our local municipality, which is part, I think Garfield has 8 to 10 municipalities that they administer court for. And that because it is law, local law, that they must administer that local law, and they're upholding that. And as I mentioned earlier, myself and Mayor Annette Blackwell from Maple Heights joined together and put together a one-pager, and the court includes that in all eviction notices that goes out to residents so that they are made aware that they live within a paid-up-state community and what their options are, and so that they are able to do all the things that's outlined in this county legislation, this proposed county legislation, but also what's also outlined in the Village of Newburgh Heights as well as the city of Maple Heights. And so that means that you can pay before your hearing or you can pay all the way up until the date of your hearing, as long as you have all monies.
So the administrative costs of all this are borne by the court?
It's all absorbed by the tenant. And so again, it's back payment of rent, it's court costs.
But there's administrative costs, there has to be.
I will presume so, yep, and that's all applied to the total.
Assumes that?
That's all applied to the total of the payment that's due to the landlord.
And you've had successful cases that you know of?
Again, that will have to be checked with the court.
It would be important to know if there are successful cases.
Yeah.
Thank you.
And one of the things I will do, I could just reach out to the court and chairwoman, if you don't mind, I'll have my office email you. Okay. All right. Perfect.
Madam,
All right.
your microphone.
I don't want people to hear my clicking of the pen, etc. So if you would give the information to the clerk, and she will give you her card as you walk past her.
All right.
Thank you, ma'am.
Again, thank you, chairwoman, and to the committee.
Madam Chair,
Yes.
to the mayor, if you could come back for a moment, please.
Even you all won't let me. Good morning, Councilman.
First of all, I would like to thank you very much for coming to the hearing this morning and for your support and for your very clear explanation of how this legislation benefits both tenants and landlords, and also to make you aware that our county legislation contains the exact same definition of reasonable late fees that you have. It's $25 or 5% of the monthly rent, whichever is greater. Thank you.
Okay. All right. Thank you. Is it safe now?
I think so. Thank you. Next on our list, Madam Clerk?
The Honorable Mayor Michael Brennan.
Mayor.
Good morning, Chairwoman Stevens, members of the committee. I'm Michael Dillon Brennan, Mayor of the City of University Heights, and I'm here today to speak in favor of the proposed County Council Ordinance 2023-0004 to implement pay to stay as an affirmative defense in an eviction proceeding. Housing insecurity is the twin of food insecurity when it comes to keeping people precarious, holding people down and holding them back. If you own your home with a mortgage payment and you miss a payment, you could miss months of payments before you see a foreclosure action. Homeowners are better suited to weather a temporary personal financial disruption. Tenants in a rental, on the other hand, get no such grace. Miss a rent payment for any reason, even briefly, and that could lead to a 3-day notice and an eviction. Pay to stay would allow tenants to pay what they owe plus a capped late fee to avoid an eviction, or to serve as a defense against eviction brought for non-payment of rent where such tender is made. There are several good reasons already stated in the ordinance for instituting pay to stay, so I won't go over all those here, but I would like to offer one more. As large corporations and private equity buy up more and more of our rentals here in Greater Cleveland, we cannot and should not expect benevolence by these out-of-state corporate landlords. We will have to mandate by law protections for tenants, starting with pay to stay and probably in other areas as well. While the City of University Heights has not, as of this time or as of yet, taken up the issue of pay to stay, as mayor, I can tell you that my administration supports this proposal and other proposals that promote safety and security for tenants in rental properties. That concludes my prepared remarks, but I'm happy to answer any questions you may have.
To my colleague, Mr. Gallagher.
Mayor, welcome. I didn't catch your city.
University Heights.
Did you pass this?
No, I was just saying we have not, as of this time, taken up this issue.
Why not?
Well, I could be candid and say because the chair of our Building and Housing Committee hasn't been particularly active. It is something that I do support.
Well, as mayor, couldn't you propose it?
As mayor, I've proposed a number of housing issues that have basically just stayed in committee or have been not acted on.
So you don't, I'm not understanding, you don't have support of council, or the council's not interested, or?
Well, the council simply hasn't taken up this issue. We do have a fairly robust rental registration system. There are local provisions that our municipal court, Shaker Municipal Court, does enforce with respect to some other protections. This particular matter simply hasn't been taken up yet. We just had a second vacancy on our council. It was our Building and Housing Committee chair. She resigned last week. I'm hopeful that whoever comes in and takes over is a little, takes up this issue.
My concern all the way through is why is the county getting involved in this? And where the costs are going? And no one seems to know where the costs are going, and no one seems what the costs are. And there's at least one municipal court that I've been told that has denied a city that passed this. And then I'm hearing there's one municipal court that is fine with it, but we don't have actual success ratings regarding people that have gone through this. So I'm wondering how, is this just some vapid, we feel good legislation, or does this have teeth? And I don't see it with teeth right now.
Well, I think it has teeth to the extent that a landlord is, if they bring an eviction action for non-payment, and there's been a tender that's been made and that can be demonstrated, then costs should be borne by the landlord in that instance. I am an attorney, and I have represented tenants in court before, and I would anticipate that a court would assign costs in a wrongfully brought eviction action to the landlord. Now, in an action where there may be other instances where costs would be borne by both parties potentially, or maybe there could be a provision where something is assigned to a defendant if the defendant has done something incorrect. If, for instance, I'm just kind of hypothesizing here, if a tender was made after an eviction filing was brought, would that still count as an affirmative defense? And would that change, the shifting of where the costs would go? Arguably, I could see where the costs might go to the tenant in a situation like that. They're paying a late fee that's being, that mirrors what the city of Cleveland has done on their pay-to-stay legislation. But if you make a tender before an eviction proceeding is brought, and the landlord brings an eviction proceeding anyway, and that proceeding is based solely on non-payment of rent, I would anticipate a court would assign costs to the landlord for having brought an action that the landlord did not prevail on.
And you bring up good concerns and questions, and mine also was earlier on. You weren't here.
Yeah, I came in late from another meeting.
It's just, to me, so you have an eviction, somebody files an eviction for non-payment. And as you know, evictions can go on for a while. Is there escrow? Is that person really interested in paying month to month to an escrow account? Or is it just we go to the end of, say, and it could go on 7, 8, 9 months or longer, and then that tenant just walks away? Who's responsible for making that landlord whole? The city, the county, the court?
Well, I think in that instance, the tenant is still responsible if the tenant has been unjustly enriched by staying at the property without making any payment whatsoever.
I think this legislation would make perfect sense if there was an eviction filed and the tenant started paying into an escrow account. And that would prompt, I would imagine, that landlord to maybe even take a hit on a loss of rent to get that money into his account and to keep a tenant that had a problem and he wanted to keep, or she wanted to keep. If there's no end game here, and the end game is the tenant walks away, the landlord's out money, and somebody should be held responsible for that. My concern is if this is a county ordinance, then the county's responsible. And the cities, while not opting out, they're automatically in, are free and clear. Why wouldn't you stay in? It's free. And as I said earlier, nothing's free. Not dealing with taxpayer dollars.
Okay. Yeah, I'm not sure how we get to the point where the county is somehow responsible for.
I'm just saying there's a loss. You wouldn't take a loss, I wouldn't take a loss, because the county intervened with this legislation. Your loss arguably could be considered greater if there's no escrow payment, correct? It would be like a good faith payment to the court.
Either they've made the tender or they haven't. And I think you do bring up a point with regard to how that tender is made and whether that tender is legitimate. I suppose an escrow account would be one way of ensuring that a tender was actually made, or, you know, or further evidence of a tender having been made. You know, you go to your landlord and say, here's the money I owe you plus the late fees. I'm not taking your check. Okay, I'm going to the courthouse and dropping it off there.
Right, and that, to me, that would make perfect sense in trying to settle this dispute. And I think the courts would look a little bit more fond upon that. It would make their job a lot easier, I think, also. But not lacking that, this is an open-ended situation that could really go wrong.
So
I think we should be trying to fix problems, not make them larger.
to my colleague and to Mayor Brennan, there are two folks who look at policy and legal issues who are scheduled to speak in a few minutes. Hazel Remish, who's the policy and local and policy and state government kind of person for enterprise communities. They tend to try and think things through. And then there's someone from the Legal Aid Society, Matthew Vincel, who's one of their attorneys on their team, thinking this kind of legal step through. So let's put Mayor Brennan off the hot seat and bring these guys who are supposed to help us think better and smarter up to the table.
Sure, thanks, Mayor. You've added to the conversation, certainly.
Yeah, and I appreciate your points here, Councilman. You know, there is an issue of evidence, you know, perhaps that will need to be addressed, and as the chairwoman has put it, you know, perhaps there is somebody else here who has an idea to offer on that. But I do think, however, that would be an issue to resolve rather than not pursuing this kind of legislation.
Thank you, Mayor.
Thank you.
Next, we'll bring Hazel Remish up, the Director of State and Local Policy for Enterprise Community Partners in Ohio. Hi.
Good morning, Council, through the chair. As Vice President Stevens just mentioned, my name is Hazel Remish. I've been before this council before. Many of you know that I spent the majority of my legal career representing tenants going through eviction court. I'm now with Enterprise Community Partners as their Director of State and Local Policy. And Enterprise is a national housing and community development nonprofit organization. In Ohio, we focus on we have a statewide office that's based in Cleveland, and we facilitate a number of coalitions, housing investments, and programs to increase our housing supply, advance racial equity, and build resilience and upward mobility. We commend County Council in your efforts to protect renters in Cuyahoga County and promote housing stability, justice, and equity. Under Ohio law, as you all have heard today, a tenant can be evicted for being just 1 day late in their rent or $1 short. Ohio is actually only a handful of states that allows that to happen. In evictions, although you've heard some comments today that they can take a long time, they're actually meant to be a speedy process by nature. They are meant to be speedy in their nature in order to make sure that that landlord, if they're entitled to get their property back, they can get it back. This ordinance doesn't change that. It doesn't actually slow that process down at all. Pay to Stay provides a pathways for renters who offer the rent late and allows them to stay in their home. This is a common sense, really a common sense policy tool that protects renters, particularly those who are disproportionately impacted by evictions, homelessness, and entrenched in structural and economic inequities. We heard today from someone who actually went through that eviction process. It's not an easy process to navigate, and these tools in particular can help tenants navigate that and can also, and importantly, an important note is to note that it also protects the landlords by making them whole. While providing for housing stability for renters, the legislation also, we commend council for the expanded definition of rent, as you all heard today. That expanded definition includes, and this is something that we haven't talked about this morning, but it also includes payments from third parties. So rental assistance programs that the county helps facilitate, vouchers, and social services agencies. All of those payments would be covered under this ordinance to ensure that landlords are made whole. We thank you for the opportunity to comment and commend council for taking this important step in our community.
Thank you. I'm assuming Mr. Gallagher has a question, a comment, or an interrogatory.
I apologize. You are?
So Hazel Remish, I'm the Director of State and Local Policy for Enterprise Community Partners.
And before, she's been infamous with me anyway, for working with legal aid and following up on eviction policy. So our paths have crossed regularly in the last 3 years at least.
And I am an attorney by trade, so I spent the majority of my career representing tenants in eviction court.
Okay. You stated that the landlord, this helps make the landlord whole. Take me through my scenario that I gave where you go to the eviction court, there's been no payments, 7-8 months go by, and it walks away. Landlord's not whole. Who makes that landlord whole?
With all due respect, Mr. Gallagher, so when you were stepped out, one of the things I mentioned was that eviction actions are actually by nature meant to be speedy. It's meant to be a speedy process. It's not meant to take 7 to 8, 9 months. However, there are instances when an eviction action might take a little longer. I'll give you an example. For the most part, from the time that a landlord files that eviction, the hearing will happen within 30 days. And that hearing is the trial. That hearing is when the court makes a decision about whether or not they are going to grant that landlord possession of the premises or if the tenant gets to stay. That it happens within a 30-day window, give or take, depending on the jurisdiction. However, there are instances where that process might take longer. And in those instances, the revised code under 1923, which governs the eviction law, it actually says that if you are going to get a continuance that is more than 8 days, the tenant is required to come to court and post a bond. It's not called an escrow, it's a bond. It's a bond where the tenant says, okay, well, the case is gonna take a little longer, and so I have to bring my money to court. And that just sits there until the court makes a determination about who the money is entitled, where the money goes, what happens to the property. So that process is already in place. It's actually statewide legislation that exists under the eviction landlord-tenant law.
Yeah, but specifically the bond says every dollar owed is to be placed in the bond?
The court essentially makes a ruling about what the landlord is, what the tenant is required to bring to court.
Shouldn't this legislation say that?
It's already codified in the state. It's already codified in state law.
But it doesn't specifically state the whole amount.
No, but there is case law that has already gone through that process of determining what that amount is.
In your trials and tribulations, how many of these have you seen beginning to end?
Like I said, I spent the majority of my career doing eviction work. This did not exist, has not existed for the majority of my career.
It's been
Yes, I mean, well, we're really talking about a short period of time, 2021. And so I will say, I'll defer on that question to some of my colleagues from the Legal Aid Society who are actually in all of those suburban courts that can tell you a little bit of what is happening in the courts. But yeah, so I'll defer to them on that question.
Thank you.
Yeah.
So, excuse me just a minute, Matthew, you're the next batter up, but don't come up yet. Can you make a text to find out what kind of numbers we're seeing? Okay, thank you. because that's been a consistent question of my colleague. If you have your cell phone and you can reach out to your colleagues, or if you know it already, that's wonderful. But let's give him a chance to collect how he wants to share those numbers before he gets up here. Okay. Any other questions for Hazel?
Madam Chair?
Mr.
I'm
President?
trying to grasp, to use your example of 30 days through the eviction process, give or take, this legislation, if the tenant takes advantage of it, actually pays every penny, regardless of how long the eviction process takes. Is that accurate?
That is accurate, yes.
I'm a landlord, so I'm actually thinking, what is the downside, if there is? Maybe my question is, what do the critics, I don't know if we have any in opposition to this here today, but can you speak to what the critics have a concern about? Or other cities who say we're not doing this, maybe? What are they saying?
I will say that this is not unique to Cuyahoga County. There are other municipalities across the state that have implemented these sort of protections as well. Some of them were protections that were in a response to the pandemic, where they were trying to, make sure that people had a safety net. And those laws were set to sunset. But in fact, some of those jurisdictions found that they were having such positive results that they did not allow those ordinances to sunset, but rather implemented them as a long-term protection for renters. So this is, while it's fantastic and great for Cuyahoga County to be taking this step and considering it, we're not unique in that it's a movement across the state, across the country. And so we have not heard a lot of setback. We have heard the opposition in situations like this where we're having the conversation initially, but once the ordinance is in place, we've heard a lot of positive results.
Yeah, I keep thinking I'm getting my money as a landlord. I'm getting my money, so I'm not yet sure actually what the downside, if there is a downside, the negative of what we're hearing.
And in fact, not only is the landlord getting their money and their late fees, but they're avoiding having to re-rent that unit and the cost of turning over that unit.
Does this also impact or the fact that one of the mayors said that some of the landlords are international or out of state? So I can see that being very impersonal. You're a dollar late, you're a day late, you're out. But then the tenant comes up with the money, and it could be very bureaucratic and business-like. No, we're evicting you out. You get paid. That out-of-state or international landlord is made whole, and he's not in town. He's getting his money, and we help them to govern themselves accordingly in some way. Is that a
absolutely
legitimate scenario?
Yeah, because not only are we suffering from, big corporations, LLCs, and international corporations coming in and acquiring properties because of the low cost in some of our areas, but we're also, what that causes for a lot of tenants is then they don't know who to pay their rent to, right? They don't know who is actually the owner of the property. They might have gotten notice that the property was bought out by somebody else. And so it really gives them an opportunity to make that connection. So we're assuming that tenants generally, they come to court, they weren't able to pay their rent. But sometimes tenants can pay their rent, they just don't know where to pay it to, because of that change in, hands of the properties. So there's a lot of different scenarios that would be covered, but yes, this one in particular would help make that connection for those international out-of-state landlords who are now owning a lot of our properties.
Thank you.
Okay.
Thank you so much.
Thank you so much. Next, let's take a talk with one of our council people, Councilman Walter Stewart from City of Warrensville Heights. Your turn.
Thank you. Good afternoon, everyone. I'm happy to be here today, and I want to thank you all for allowing me to speak, and I want to thank my colleague, Andrea Mitchell. She really explained the situation very well, and I concur with everything that she said, and I appreciate her stating before she sat down that I deal with this every day, and I know that the legislation that was passed in Warrensville is benefiting the residents. The majority of my residents are young, single African-American women. All right, 73% of the households. And then I have the highest number of children. I have quite a few elders too. And this management company, now there's another side to this thing now. This management company has been caught doing things like giving a person a 3-day notice. And then, I had a recent case like this. Then when I looked at the paperwork that the resident was crying, she wasn't behind on her rent, but they actually went and took stationery from the previous management company, probably 4 or 5 years old, and saying that she owed $6,000 or $7,000. And if it hadn't been for pay to stay, they would have got away with that. But pay to stay had already kicked in. So when I went to court with her, all right, when the judge looked at the paperwork, his hands started shaking. Their attorney never looked up from his papers, didn't say one word, but his assistant looked at the lady and said, "Oh, you don't owe anything, and I apologize." And the judge threw it out. Now, if pay to stay was not in place, they would have bullied her and tried to get that money. She wouldn't even made it to court. And these are some of the things that we have dealt with. You know, we have an association called the Granada Gardens Tenant Association. We had no help or support. We couldn't even see light at the end of the tunnel until that pay to stay legislation, and then we're getting support now from Legal Aid, the Fair Housing Center, and NEOC. All right, so pay to stay is giving us time to reposition ourselves, because a lot of people have been evicted, and the harassment has just been, you know, some people rather than fight something, if they're threatened, especially threatened with eviction, all right, they panic, all right, and we had quite a few residents that did that. But when they saw pay to stay, when they heard about pay to stay, then for the first time, there was some relief there. Now, the management company, shortly after pay to stay was passed, they immediately went to court and tried to appeal it. So what I did, I rushed out, couldn't wait on the volunteers. I rushed out and I had 1,000 copies of the pay to stay legislation ran off, and I went out there at 12 o'clock on Sunday and passed it all out by Monday morning. So we need that legislation. I know there are things that still need to be worked out. Thank you. Thank you. Okay. Yes, ma'am. Yes, sir. Yes, sir.
Yeah, and in dealing with this, you're dealing with human beings, human feelings, human situations. I understand that. So you're telling me this lady went to the Garfield Municipal Court?
No, Bedford.
Bedford Municipal
Yes.
Court.
Mm-hmm. Yes, sir.
And you're saying pay to stay saved her. How did pay to stay save her? Because it sounds to me the landlord filed an eviction in Bedford.
But they told her that she had 3 days to vacate the premises. Mm-hmm. What I'm saying is, I don't believe that she would even have the opportunity to go to court, if pay to stay was not in place. See, the pay to stay legislation will, they have to give people time, to show, to come up with the money. they're entitled to a court, to some type of court date. Give them time. They can't just be thrown out in the streets. This property management company who's been there for about 2 years, and they're having problems all over the country doing the same thing. They came in with that attitude. They gave me a three-day notice. And I never been behind on my rent. One time they say they say I didn't pay my rent, but I did, So when I challenged them publicly, all of a sudden they said, "Oh, we overlooked your check." So there's I'm not saying that there's nothing negative on the side of the tenants, but it's two sides to this thing. And I know from experience, from what we have been going through and still to some extent, a large extent going through here in Ward 4 in Warrenville, okay, we are dealing with a very, very serious situation. And we need, I was so happy to hear that the county council, this Pay to Stay legislation 2023, was, working on making it a county legislation, passing a county
that
Pardon?
You already have it. Why would that be important?
Well, it's important because I think everybody should be covered, not just in Warrensville. You know what I'm saying? There are people being harassed. I see it on a daily basis. Mm-hmm. They are being harassed. Some people have paid their rent and they're still being harassed. Yeah. All right? But see, the management companies, they use these, before Pay to Stay, they could use any excuse in Warrensville anyway, any excuse to threaten people, just any little excuse to threaten people, say, okay, you got a 3-day notice. They put one on my door. And but now they're a little more reluctant to just do that. It's not as widespread as it was. And Pay to Stay is very, very significant. I have not seen the residents showing any type of release or stress until recently. All right, I'm not saying Pay to Stay is the complete solution, but it's a step. There are things that's got to be worked out, but it's a step. It's a step. The residents have something. Before they didn't have anything to fall back on. Now you mentioned escrow. Mm-hmm. Well, it's sad to say, but I learned from experience. All right, some of the residents, and we've had people to come out and talk about escrow, but some of them, especially the older ones, they feel like it'll be some type of retaliation if they put their rent in escrow, this, that, and the other. So some have put their rent in escrow, but then you got some that they'll say it, but they just won't do it. You know what I'm saying? We can't make people put their rent in escrow. So I'm all for the Pay to Stay legislation, all for it at the municipal level and the county level. I'm not saying that there is not still, legitimate concerns about, how it's going to be implemented, but I'm all for it, and I'm going to be, here to support it, 1,000%. I know what it has done for the people in my ward. They see some hope. They see some hope. I have personally taken people regretfully who have been evicted, just dropped them off at hotels, motels. They said, well, somebody going to come and get me. You know what I'm saying? I've done that. Before Pay to Stay, I've done that. It's been horrible. There just hasn't been any kind of relief or something some assurance. The residents have some kind of assurance now, some kind of hope, and I do see this, that nationwide, that there is a growing tendency and movement among renters in this country to fight back. It's all over the country. I'm not saying that all landlords or property owners are corrupt, but I know we're dealing with a very corrupt company, and so that's what I'm here for, to support it, lock, stock, and barrel.
So the Bedford Court takes these filings. We could get the information for the Bedford Court on pay to stay.
Yeah. Yes.
Okay, thank you.
Okay. Thank you very much.
This local company, I'm sorry, this company, is it local or out of state or?
It's Integra Affordable.
I'm not asking the name. I'm
Okay,
just
all right.
saying,
It's not.
is
You mean, is it local?
Right.
Yeah,
are
they're
they-
right here. Yeah, it's local. It's national, actually, but they have an office here. It's national, right? And it's local. Yes, sir.
And Madam Chair, if I may, does your legislation differ in all from what we have before us today? Is there anything in your legislation that might be unique or that just differs slightly from what we have? The previous mayor mentioned that their legislation has a cap of $25 or 5% of the court costs, where ours does not. Does your legislation have any unique features in it, or is yours identical to what we have, if you know?
It's pretty much identical to what you all have. Mm-hmm. Pretty much identical. Yes, it is. Mm-hmm.
Madam Chair.
Yes.
Thank you very much, Councilman, for being here this morning and for your support. And I just want to stress the importance of the testimony that you just gave. You pointed out very persuasively how pay to stay has both informal and formal benefits. Pay to stay legislation creates expectations around landlord behavior that once it's put in place, that many landlords are willing to follow, and it changes behavior in positive ways. We don't really want to go through eviction processes, and we don't really want to go through court cases if we don't have to. If we can create this expectation and most landlords voluntarily follow it, that would be tremendous progress, and that's part of what we hope to accomplish here. Thanks again.
And thank you, sir.
Any other questions? Thank you. Next, I believe Gary Benjamin, who represents Greater Cleveland congregations.
Actually, I'm here with a different hat today.
Okay.
Gary Benjamin, I'm a Cleveland Heights resident, and I'm married to the president of council who can't be here today. So I'm speaking for her. I'm also co-chair of the Housing and Economic Opportunity Committee, subcommittee of the Racial Justice Task Force, which put forth the pay-to-stay legislation last year. In Cleveland Heights, this came up during COVID. It was passed unanimously by the council in 2021, but it was to sunset December 31st, 2022. And that's why the task force brought the legislation forward to make it permanent in the city. And in that process, we had the lawyer from Legal Aid come before us and talk to us about how it was working. And it was working. We don't have thousands of eviction cases in Cleveland Heights. We have maybe 200 or 300 a year. And most of them are worked out in a settlement in the court. I know the judge very well because I worked with him as a magistrate for 2 years. And the process is usually that the case is filed, the eviction is filed, and within 30 days, as a prior attorney said, there's a hearing. And At that hearing, things are, it's not like a normal case where a schedule's set out and 8 months down the road you have trial. You have it quickly. The eviction's supposed to happen quickly. It's supposed to be a speedy process. And the pay to stay in the past, what would happen would be in a non-payment of rent situation, the landlord, even if given full rent, late fees, could refuse it and still go forward with the case, even though the family involved had offered the money. That's the thing this is supposed to change. Instead of rejecting that money, the landlord's required to accept it in order to go and to go ahead with the tenancy until it ends. So we've seen some pretty good results. I don't know the numbers from our court, but I can get them if you'd like me to. I also would say the only difference in our ordinance and your proposed substitute that I'm seeing with my naked eye and going by memory with what our ordinance says is we do not have the tender provision for a letter or a promise from a nonprofit to pay in the future. We don't have that because our local judge thought that somehow it would get in the way of him working out settlements. But we also have source of income discrimination legislation. And if you bring that letter forward in Cleveland Heights Municipal Court, what the judge has done in the past anyway is said, you have a letter, that's a source of income, they can't discriminate against you because of that. So that the two working together have also been very salutary in our court. The Racial Justice Task Force took this up a year and a half ago when we first came into existence because the tenants in Cleveland Heights are about 60% African American, and homeowners are the opposite, 60% Caucasian American. So we felt there was a racial issue here and brought it forward. And both times it's been brought forward to our city council, it's passed 7-0. So we see it as a need and support it. That's all I have prepared.
All right,
Any
thank you.
questions?
Any questions? Councilman Gallagher?
Sir, thanks for being here. So once again, Cleveland Heights Municipal Court handles these, and we can go to their docket and see where pay to stay has been helpful.
Yes, I'm guessing you should look at the answers filed on behalf of tenants and how often it's raised. It's probably there in just about every case, every non-payment case anyway. Landlords do have other rights to evict, other violations of the lease, or just they want possession because they're going to do renovations or whatever. So this particular piece is aimed at the particular problem, which was landlords were rejecting payment of rent.
Right.
To go ahead with an eviction, even when the only issue was payment.
The Cleveland Heights has pay to stay,
Yes,
so why is it important that the county have it?
well, not to us. No, we're going to do what we're going to do. But,
Exactly. Well, that would be my response.
Yeah.
I was a city councilman, and I would, at that point in time, my pledge was to the ordinances and laws of the state of Ohio and the city of Strongsville. There's no mention about Cuyahoga County in my oath ever. And I don't think that is ever going to happen, which is why I don't understand what the county's doing in the business of the state or the city.
but you do have an oath now to Cuyahoga County.
To Cuyahoga County.
All I'm saying is that we think this is a good salutary ordinance that helps people that need it, when they need it.
Well, I guess
Doesn't hurt landlords. As far as we can see, we have had no beefs from any landlord organization or individual landlord. We actually reached out to some of them in our work as the Racial Justice Task Force, and one landlord showed up and basically said that they'd follow the law and they didn't see a big problem with it.
Right.
So, you know, it's been good for everybody. And that's, the reason we're supporting it countywide is it's just a good thing.
Well,
You're right.
again, what's good for Cleveland Heights might not be good for somebody else, and that's why I think this should stay in the cities. And it's in many cities, but I do find it very interesting that while everybody's claiming it's been a grand success, nobody can point to grand successes.
Well, I think I just did. at
Well,
least-
the docket of the court will show that.
Yes, and when the judge appeared before us, and so did the legal aid attorney, and talked about successes. People who were on the verge of being evicted, but the landlord had to accept the money this time, and they did.
Sounds to me more like mediation, and actually, I think the court should, and they do, but I think they should participate a little bit more in mediation if they, but again, there's a cost with that, I understand, but thank you for being here.
This helps with mediation. That's what our judge's point was.
Oh, that's in your
Helps with
legislation, that pay to stay demands mediation?
It doesn't demand it, but it gives the judge or the mediator another weapon, if you want to say, or another piece to put on the weight, on the scale.
Well,
when
that's
they're
the
talking
court,
to the
that's not your
landlord.
legislation, that's the court provides that.
The court provides mediation. Our judge does his own. And he has said that this has helped in a lot of cases that won't really show up on the docket because they don't have to make a decision.
If they don't show up on the docket, it didn't help.
Yes, it did.
Well-
If it's mediated, look, I was a magistrate. I know what I'm talking about.
Yeah.
Mediation requires there be power on both sides. This levels that playing field and allows mediation to go forward with more balance on the tenant side and less on the landlords. That I'll grant you. But the way it is now, in a payment issue, all the landlord has to do in any of these other municipalities in the county is say, I won't take your money. And go ahead and get an eviction. That can't happen now. Not in Cleveland Heights.
In all years as a mediator, how often did that happen, where money was laid on the table and the landlord walked away?
I was a legal aid attorney for 5 years, and I supervised 7 or 8 other lawyers. I've done some of this on my own.
Yeah.
I'm not sure where your question was going exactly, but
Well, I mean,
mediation
does
happens
it
in all
happen a
these.
lot, or does it happen a little bit?
Trying to settle these cases happens in
I
every
was
case.
specific in my question, where money's laid on the table by the renter to the landlord walks away.
Boy, I'd say, it's hard to put a number on it, but 2 out of 10 times.
Really?
A lot of times the tenant doesn't have the money.
Well, then
That's
they
the
can't
biggest
lay it on the
problem with these,
table.
yeah. The tenant doesn't have the money, they end up in court.
Thank you.
But in 2 out of 10 cases, I'd say that the tenant came forward with the payment, and the landlord said no.
The docket will show that.
Yep. That, I don't know if you're gonna be able to actually get data on that, the way the court is. I don't know if the court keeps that way. You know, they keep who brings in pay to stay as a defense, that will show up.
Okay. Thank you.
Anyway, any other questions?
No other questions, thank you.
Thank you.
Now, we have Matthew Vincel, who's from Legal Aid Society. Do you have some answers for us, I hope?
Good morning, Madam Chair, and to the committee. Thank you for the opportunity to speak today regarding this important legislation. My name is Matt Vincel. I'm the managing attorney of the Housing Practice Group at the Legal Aid Society of Cleveland. As you may know, Legal Aid represents tenants in eviction cases throughout Cuyahoga County. All of the municipal courts in the county, we have attorneys representing tenants at. We also represent tenants in Lorain, Geauga, Lake, and Ashtabula counties as well. I guess I want to jump directly into sort of some of the issues that have been raised by the committee this morning and talk a little bit about the on-ground application of pay-to-stay ordinances, sort of how it works. And first, addressing the issue, I believe it tends to be very difficult to quantify the impact of this legislation because, as the previous witness was testifying to, Oftentimes, the impact of the legislation is to provide a tenant with leverage to resolve an eviction case by making payment to the attorney or making payment to the landlord. So I would say probably 80% of the cases where we are utilizing pay-to-stay ordinances, we're utilizing it in the negotiation process. And for the most part, landlords and their attorneys are accepting these pay-to-stay ordinances as applicable. And so when we are able to, so prior to an eviction hearing taking place, we will reach out to the landlord's attorney, ask for a ledger, get the amount that's due, and then speak to our client who either is seeking the payment through a rental assistance process or might have the payment on their own. We show up in court, we have the payment, the landlord accepts the payment and dismisses the case. And when that happens, all that the court's docket is going to say is case dismissed, because the landlord goes in front of the court, goes in front of the judge or the magistrate and says, Your Honor, we'd like to dismiss this case. Payment has been made by the tenant. So hard to quantify then the impact, but we certainly have seen in our practice an increase in the interest in landlords in these pay-to-stay jurisdictions of accepting rent payment that satisfies the obligation that's owed. And to address Chairman Gallagher's question about was it frequent that we would see landlords who are not interested in accepting payment? It's not frequent, but it happens. And I will say it's happened more frequently in the context of rent assistance. As you probably know, within the past 3 years, there's been a proliferation of rent assistance programs offering to help tenants make payment of past due rent. And what we've seen is, even though this money is as good coming from these third parties, from these nonprofits, or from the state and the county, the money's just as good coming from them as it is coming from the tenants. We've seen some reluctance on the part of landlords in accepting that money. The pay-to-stay ordinances have addressed that because, for the most part, they include provisions like this ordinance. And Madam Chair, is it okay if I continue? Okay. Like this ordinance, they address the payment from a third-party rent assistance provider. And so it's been critical to have that tool. And I think it's critical to offer that tool to all the residents of Cuyahoga County, because what we see, we appear, for example, in Bedford Municipal Court, we may have two tenants, one from Warrensville Heights, who has payment in full or has gone through the rental assistance application process, has a letter from the rent assistance provider saying payment will be made. We can go in front of Judge Schmeling in Bedford Municipal Court with that, and the case will be dismissed. Now, if we have another tenant who's from another municipality, and as you know, in Bedford Municipal Court, the jurisdiction includes several municipalities that don't have pay-to-stay ordinances, we may have a tenant from one of those municipalities who's in the same exact situation. They have gone through the rental assistance process, they show up in court, rent assistance is ready to be paid, we go in front of the court. It won't matter necessarily that we have that letter saying we can make payment in full today. If you're not in a pay-to-stay municipality, then you don't get that protection. And it creates this inequity that is apparent. I mean, if you go to one of these courtrooms where there's multiple municipalities, there's a clear inequity. If you come from Warrensville Heights, you can pay and stay. If you don't, then you might be evicted. You might be homeless in 10 days, even though you had the money in your hand. There were a few other issues that I wanted to address. I believe it's been addressed, but the eviction process, it's designed to be fast, and it is designed not to permit the tenant to ask for continuances, to draw it out. So if you're a tenant, you can get a 7-day continuance, and some courts won't even offer that. It's up to the discretion of the court. You can get a 7-day continuance. Any continuance after that, if the court chooses to grant it, you're required to pay a bond of the monthly rent amount. So you have to pay your monthly rent into court. And if it's going to be continued any other way, it has to be with the permission of the plaintiff, of the landlord. So generally, we see these cases turn around in 30 days. We get a hearing in 30 days, and we have to either arrange payment, arrange some kind of agreement with the landlord, or go in front of the judge or the magistrate and assert an affirmative defense. I can probably count on two hands the number of times we've had to actually assert the affirmative defense of pay to stay. Like I said, it's rare because the landlords and their attorneys accept the fact that if they walk out in front of Judge Melling, say, in Bedford Municipal Court, and say, yeah, this tenant can pay, but I don't want it, that he's going to dismiss the case. And so they would much rather take the money. I wanted to address one other issue that I think, Councilman Gallagher, you may have been bringing up, in talking a little bit about the process of eviction. So there's two parts to an eviction. There's the eviction part, which solely determines who's entitled to the property, whether the tenant can stay there or not. There's a separate part of the eviction that determines liability. So does the tenant owe the money to the landlord? And that second part usually takes place entirely separate from the eviction part. So the eviction part, the courts try to push through quickly. Within 30 days, like I said, there'll usually be a resolution of that. The money claim, the claim for damages, past due rent, anything like that, courts will treat that as sort of normal civil litigation. So it might take a few months for that to play out. But ultimately, the pay to stay ordinance is not resolving the tenant of any liability to the landlord. So if a tenant goes in front of the court, asserts the pay to stay affirmative defense, prevails, case dismissed, that doesn't mean that tenant doesn't still owe landlord that money, and the landlord can't still pursue those separate money claims. I hope that all makes sense. What we've seen is landlords in the context of these pay to stay ordinances, enjoying the fact that they have some certainty about what is to be expected, because in the multiple municipal courts that we practice in, we see different approaches from judges in court. So one court may send you to mediation. One judge may pressure the landlords to take the money. One magistrate may say, even if you have the money, it's all up to the landlord. The tenant gets evicted. This creates some certainty across the board, having the county implement this ordinance. If a tenant shows up in court and can make payment of reasonable late fees and past due rent, then they get to stay in the property for as long as the lease term continues. Thank you for the opportunity to speak today. I'd entertain any questions if the committee has them.
Mr.
Madam Chair.
Gallagher.
So what I've heard is all this is a tool that basically the courts can use and the representative or the renter can use. Isn't that best left in the hands of the courts? Like you were saying, the court could send us to mediation, the court can do this. The court has broad powers to do it, really whatever it wants to do, when it wants to do it within the course of the law. I'm hearing this is a really great idea, but it's a tool. And I'm hearing it's a really great idea and it helps us in court, but you're not going to find it on the docket anywhere.
Well, as I mentioned,
and again,
I'm sorry.
why? And I'm sorry, but why would the county step into this when cities are fully capable and probably have a better position than the county legally to control what goes on in their cities? Why would the county get involved, especially when you have cities that already have it?
Well, thank you, Councilman Gallagher. Let me address your first question. I think, so it certainly is used as a tool the way we use it in the process of negotiation prior to the hearing. And I believe that sort of applies to any legal defense that's created by the law. So there's statutory defenses to evictions in the state statute. We often use those in the same way. They create leverage for us to try to resolve the case. Courts may use those too in that way. If there's some claim that there's conditions issues in the property that exceed the amount of the past due rent, there's a statutory provision in state law that potentially gives the tenant an affirmative defense. We might use that as a tool, but if we can't use that leverage to resolve the case, then it becomes an actual affirmative defense that we are asserting in court. We don't have to do it much because it's, in my opinion, because it's a successful ordinance that has been accepted by the landlords and their attorneys. But ultimately, it could be more than a tool for when we're dealing with landlords who are not just accepting that. I do think the idea that it should be up to the courts to decide, that causes me some concern, because I certainly in my practice have seen, some courts have multiple different magistrates, and one magistrate may have a different approach than another. And I don't think that that's, so a tenant going into those courts may be treated differently, have a different outcome depending on the magistrate that they're in front of, excuse me. That would cause me concern, because I think that tenants that are appearing in court in eviction cases should get the same kind of treatment. And I think the pay to stay ordinance ensures that, and that's why I think it's important. With regard to the county taking it up rather than the individual municipalities, I think it goes back to that patchwork issue that I addressed before, which is it paints a clear picture of inequity when some tenants are coming up, they're able to pay to stay in a courtroom, and other tenants come up and they can't. And even though they have the money or they have the rent assistance, they are evicted, potentially going to be made homeless within 10 days. It's such a critical issue that I think it's worth the county taking this step. And then if municipalities want to opt out, they can do that. But I think tenants deserve this right throughout the county.
And again, the granting of rights, I don't think fall within the purview of the county, certainly the state.
I misspoke, Chairman Gallagher. The affirmative defense. It's
Well, it's in there. That's why I brought it up. And you had time to pull up cases from the courts. Did you find any?
I had time to poll my coworkers, and we do keep track of the actual decisions that we get from the court enforcing pay to stay ordinances. We have 5 decisions from the court that I know of where the court is actually enforcing pay to stay ordinances. Mm-hmm. Now, there's a multitude of cases, and I could try to collect those and count them up, where our attorneys, our clients can attest to the fact that pay to stay in the course of negotiation resulted in a resolution. There are also probably multiple situations where we didn't even know that the pay to stay was a consideration of the landlord or their attorney. So the landlord may show up and say, if this gentleman has the money, I've got to accept it. And we show up with the money. We don't have to discuss pay to stay, but it may still be in the back of the landlord's mind.
That's the tool.
Right, correct.
It sounds that the tool's there, but you want it codified in some fashion.
Well, because if it's not codified, then the tool isn't there. We can't use it as leverage if it's not in the.
And if we were to pass this and cities opt out, don't the inequities grow greater for those municipal courts?
Well, so it is possible that if municipalities were to opt out, then the same sort of patchwork would develop that we see now. I don't anticipate that that's going to happen, just because of the success we've seen in the municipalities that have passed these pay-to-stay ordinances. And our interpretation is that the landlords and landlords' attorneys are not particularly frustrated by these, because in most cases they would accept, as you mentioned, they would accept the rent anyway. But this deals with those cases where the landlord, for some reason, is not willing to accept the rent or the rent assistance.
Right. And again, I'm waiting to hear from opposition. I'm sure it's out there. Thank you.
Madam Chair.
Yes, Mr. Miller.
First of all, in regards to the patchwork issue, I would remind everyone that we wrote to the mayor and the council president of every municipality in the county asking for their testimony, either here or simply send in writing to our clerk, and so far we have not received any negative testimony. So I'm not saying it isn't out there. There's probably going to be some, and people are going to say, "Well, I didn't hear about it," and so on. But so far it's looking pretty favorable. The first question I have for you is whether legal aid has has attempted to work with Pay to Stay in the Berea Municipal Court, and whether you've experienced the same problem that the councilman referenced about Berea Municipal Court not respecting Pay to Stay.
Councilman Miller, thank you for the question. I will say we have not experienced that. To my knowledge, we haven't attempted to assert Pay to Stay as a defense in Berea Municipal Court. Berea is a court that has not a lot of evictions. I believe it's in the realm of 200 to 300 evictions a year. So we're not in that court quite as often as we are in other courts. To my knowledge, we've never tried to assert it, so we've never gotten the sort of negative ruling that has been discussed here today.
Okay, and Madam Chair, to the witness, are you familiar with the substitute version that we accepted today?
I am.
And in your opinion, from a legal standpoint, does this legislation pass legal muster in terms of respecting separation of powers and respecting our relationship with state ordinances?
I believe it does, Councilman Miller, and in fact, I do see that in several of the ordinances that have been passed in the municipalities, go a little further than this and perhaps would encroach on what you're referring to. And I haven't seen those challenged at all. And they've been in place for a couple of years now. So in my opinion, if landlords and their attorneys were interested in challenging an ordinance like this, that challenge would have already come forward, and I haven't seen it. So I'm not concerned about the language of the ordinance itself.
Thank you very much, Madam Chair.
Thank you. Any other questions? Thank you for your comments. Thank you for taking the time to be with us today.
Thank you, Madam Chair.
Our next person to speak on the record is Mayor Annette Blackwell from Maple Heights.
Good afternoon, Madam Chair, distinguished council persons, Mayor Annette Blackwell, the City of Maple Heights. I'm not going to be redundant in anything. We've spent quite a deal of time this morning talking about this very important legislation, and I'm not going to be able to bring numbers or address questions of how, in terms of a measurement stick of how this has helped the people of Maple Heights. And I think my colleague, Mayor Gigi Traore, spoke to what we've done collectively together as we address this issue for our residents in our cities, which are very, very close together. But I will just tell you in a summary way, for education, for our schools, we were a city that was an academic emergency, fiscal emergency, and our schools were on the verge of being academic distress. I sit on the First Suburbs Mayors and Superintendents Consortium, and we know that one of those things that impact the quality of education, the success of our students, is transiency. So when children are uprooted and moved around, it certainly affects their ability to be socially successful in school as well as educationally successfully. I'm also the safety director, of course, and so not having a community feel, people moving in and out, not having security, moms being uprooted and taking on 2 and 3 jobs has greatly, in fact, impacted truancy. We have a huge truancy issue in our schools, as well as safety, as often they feel displaced. They're new to the community, so bullying takes place at significant numbers. Black infant mortality. Maple Heights is, although we are close to many hospitals, we have the black infant mortality rate of a third world country. High numbers of black infant mortality. We do know that housing insecurity, and that stress happens in vitro, having to move. Many of my residents, when they pay the rent on the 1st, they're already, for the next 28 days, they're worried how they're going to pay it again. And Pay to Stay was something we thought would be, as we've heard just recently, the gentleman before me, a tool to help address that. Because I can tell you, with 2 and 3 jobs, they do find a way to get the rent. But often there's been many instances they've come to our Department of Human Services which also houses our senior center. I have 2 social workers there. The landlord at times will not take the rent. This gives them some power back, as the council person from the city of Warrensville Heights, both of them spoke to. And then this legislation gives the local elected officials, you're correct, we have the power and we have the smarts and we have the pulse and the compassion and the heart for our people to do the right thing in our cities. You're absolutely correct. But it gives us the ability to assist our residents. But I do appreciate the action of this county council in addressing this very important quality of life issue for all 59 communities. And we did not change the legislation. It's pretty much exactly what the county council has presented. And then lastly, as the public servants, all of us, this action serves our public in a dignified and humane way. And all of the partners here have talked about the dignity, and one way or the other, it's been implied in their responses. I think it's implied in their presence here, and it's a great turnout. The humanity of these people and being heard, the gentleman that mentioned being at 2100 Lakeside, my own brother-in-law, who has some mental issues and was having a hard time in keeping residents. He's now in a rooming house on 89th and Cedar, was a resident of 2100 Lakeside. It is a place that's temporary. It's certainly not home. But this legislation gives individuals like that gentleman there, my own relative, a way to get gainful employment, try to make their rent. But COVID upset a lot of people in the ability to do that. As work hours were reduced, their illness as a survivor of COVID, not being able to work, and most of my residents are in service industry jobs. They do personal home care for seniors. They could not work because they themselves have been infected with COVID and come down with COVID, so it interrupted their ability to work. But many of them, as they got back on their feet, got the money together, really enlisted the service of several agencies that were making monies available for them to get rent and then present that to their landlords and help us stabilize our community. And I'm not going to regurgitate all that was said here or be redundant. I've heard the concerns. I am certainly optimistic. I strongly believe that this legislation will get passed. And for those communities who have opted out of it, will see the benefit of it. They just don't live in inner ring suburbs, these people. They don't live in predominantly Black suburbs. They live all over this county. And so these districts here as county council represents all of Cuyahoga County. So therefore you represent all of the people who may very well in your own communities have these same challenges. I think Pay to Stay gives them a chance, it's an opportunity. It gives them, it's a tool that these organizations and the legal system can use. So I applaud you. I'm optimistic, and I truly do believe it's going to be passed. Thank you.
Thank you, Mayor Blackwell. Any questions from my colleagues?
Thank you.
Thank you. Due to the lateness, we've been at it almost 2 hours. I want to thank everyone for their attendance today. I don't think this can pass out of committee today. We'll need at least one more hearing, and I don't have a quorum either. So with that, I am going to adjourn this meeting, and Madam Clerk, we'll have to work on another hearing date for this issue. Thank you all very much. This meeting is adjourned.